Welcome SIE candidates, prohibited activities. The goal of this video segment is to enhance SIE's candidates' knowledge of securities-related prohibited and illegal activities. The video will cover market manipulation, insider trading rules, FINRA's IPO regulations, sharing in customer accounts, borrowing or lending to clients, exploitation of seniors, activities of unregistered individuals, and prohibited activities related to record keeping. Manipulation. The Securities Exchange Act of 1934 prohibits manipulative and deceptive practices in the sale of securities. The section of the Act containing specific anti-manipulation provisions is Rule 10b-5, which states, "It shall be unlawful for any person, directly or indirectly, by the use of any means or instrumentality of interstate commerce, or of the mails or of any facility of any national securities exchange, A, to employ any device, scheme, or artifice to defraud, B, to make any untrue statement of a material fact, or to omit to state a material fact necessary to make the statements made, in light of the circumstances under which they were made, not misleading, or C, to engage in any act, practice, or course of business that operates or would operate as a fraud or deceit upon any person, in connection with the purchase or sale of any security." Although the law is somewhat open-ended, over the years the SEC has identified some specific trading activities that are illegal. In addition, two additional rules support the prohibition of the aforementioned. SEC Rule 10b-1 states that the prohibition also applies to securities that are exempt from SEC registration. SEC Rule 10b-3 states that the prohibition also applies to broker-dealers. In summary, these three provisions prohibit the manipulation of any security, whether registered or not, by persons and broker-dealers. This section will focus on specific types of market manipulation. Misrepresentations. Under SEC Rule 15c13, it is considered a manipulative act for any brokerage firm to suggest that a firm's registration with the SEC implies SEC approval of the firm. Instead, the SEC simply requires registration. It does not endorse the firm or its activities. Regulation M. The Securities Act of 1933 governs most aspects of new securities offerings, as noted in previous videos. However, the Securities Exchange Act of 1934 also includes provisions that impact the sale of new issues, particularly the actions of underwriters participating in follow-on offerings. Prior to the enactment of major federal securities laws in the 1930s, syndicate members often manipulated the market for new issues they were preparing to distribute. After these underwriters sold their allocations and ceased their behind-the-scenes activities, the involved stocks frequently experienced notable declines, causing unsuspecting investors to incur substantial losses. To regulate trading practices concerning new issues and the firms that initially profit from their sale, the SEC established Regulation M. This rule applies to issuers distributing IPOs and those offering additional securities to the public. Under Regulation M, the SEC restricts distribution participants, such as underwriters and issuers, from aggressively bidding for or purchasing stocks currently being offered in a distribution in the secondary market. However, many of these participants are allowed to create passive markets, that is, not driving up the price. This restriction is enforced for a limited period around the effective date. The SEC stipulates that broker-dealers and underwriters may not promise to repurchase IPO shares at less than the original sales price. This manipulative practice of allocating IPO shares based on securing prearranged purchase orders from customers in the aftermarket at a predetermined price is called a tie-in arrangement, or laddering. The purpose of laddering is to inflate the aftermarket price of an IPO and encourage other market participants to buy or bid for the security at elevated prices. This prohibition applies regardless of whether the transactions are executed. Furthermore, it is illegal to urge clients prior to trading an IPO to disclose information about the price and number of shares they're willing to purchase in the aftermarket. Regulation M seeks to prevent upward price manipulation before the offering's pricing, as this practice usually results in the issuer receiving higher proceeds and underwriters garnering more in fees. However, certain exceptions are allowed when the SEC believes the potential for manipulation is low. Under particular conditions, the SEC also permits exceptions for market makers and syndicate members aiming to support, stabilize the price of the new issue. Stabilization is authorized at or below the public offering price, POP, since this activity is intended to safeguard the new issue's price from significant declines. Market rumors. Some investors have spread false or misleading information about companies to influence the prices of stocks and bonds. The rise of the internet, along with the overwhelming popularity of social media, has increased the potential to fraudulently manipulate security prices through unsubstantiated rumors. The dissemination of rumors can impact a security's price either positively or negatively. For example, to decrease a company's stock price, an individual might falsely assert on social media that the company is under government investigation. When the objective of the rumor is to elevate a stock's price, the SEC refers to this practice as pump and dump. This form of manipulation occurs when a larger investor or group of investors owns stock and circulates false positive news about the company to incite a buying frenzy, pump. Before the news can be verified, the investors sell their shares for a profit, dump. Front-running. If a broker-dealer or any person is aware of a large impending order, block trade, that has not yet been executed, they are prohibited from executing an order for a proprietary account or an account over which they have discretion. Since block trades can influence the market price of a security, the broker-dealer and/or associated persons have an opportunity to profit before other market participants can act. This prohibited activity is known as front-running. Similarly, if a broker-dealer or any of its associated persons possess material, non-public information about block trades concerning a company's stock, they are barred from placing orders for any related security of the company, for example, convertible preferred stock or bonds or options in the aforementioned accounts. This prohibition lasts until the information regarding the block trades has been publicly disclosed through reporting on the tape or through a third-party newswire service. When a partial execution of a block occurs, the trading prohibition remains in effect until the execution of the entire block is made public. For the purposes of this rule, a block trade is typically defined as a transaction involving 10,000 shares or more, or options representing that number of shares. However, in certain situations, FINRA may classify a smaller number of shares as a block. Trading ahead of a research report. Due to the potential for abuse, industry regulators have long been concerned about the relationship between research departments and trading desks. Specifically, there's concern about a firm's trading department buying or selling a company's securities just prior to the release of a research report by the firm's research department. This practice is often referred to as trading ahead of research. For favorable reports, firms argue that their purchases were based on their intent to meet anticipated customer demand for that security. Without accumulation, customers wishing to buy the security based on the report's content would be compelled to pay higher prices because of the increased demand. However, regulators have rejected this argument. In fact, FINRA established a rule that prohibits a member from establishing, increasing, decreasing, or liquidating an inventory position in a security or derivative of that security based on material, non-public, advanced knowledge of the content and timing of a research report concerning that security. FINRA's rule applies to all issued securities, including debt and derivatives. Additionally, the rule covers both exchange-listed and non-exchange-listed securities. The member firm must establish, maintain, and enforce policies and procedures designed to restrict or limit the flow of information between its research and trading departments. Consequently, the rule requires the creation of information barriers to separate the research department from the trading department. These barriers prevent the trading department from gaining knowledge of an upcoming research report about a security it holds. Moreover, broker-dealers will be required to implement these barriers to evade insider trading violations. Excessive trading activity, churning. Churning is defined as excessive trading in customer accounts, usually undertaken to generate additional fees and commissions. However, how much trading is considered excessive? Although there is no specific number of trades or percentage of portfolio turnover that defines a violation, the trading activity is assessed in light of the customer's objectives. A client does not need to incur losses for a churning violation to occur. If a registered representative, RRR, has been granted discretionary authority over a client's account, it does not permit them to trade excessively. Instead, all trading must be suitable regarding type, size, and frequency, marking the close / marking the opening. In an SEC administrative proceeding against a broker-dealer, the practice of marking the close was described as a series of transactions at or near the close of trading at or within minutes of 4 p.m., which either uptick or downtick a security. Marking the close represents a potential departure from the normal forces of supply and demand that establish the fair auction price for a security and raises concerns among regulators. Similar activity at the start of the trading day is termed marking the opening. There are two primary motivations for marking the close. First, brokerage firms utilize a security's closing price to determine their customers' margin requirements. While some firms set the threshold at $5 per share, others may use a lower price. When a stock drops to this predetermined price level, firms increase their requirements to 100% equity, necessitating full cash payment for the security. Second, a security's closing price represents the final price displayed in newspapers for that trading session. Besides affecting the value of the manipulator's position, marking the close can have broader market impacts. For example, if the manipulated stock is part of an index, marking the close activity can influence the index's value. Indexes serve various purposes in the industry and are closely monitored by investors making purchase or sale decisions. In fact, simply altering a quote can exemplify marking the close. In one instance, a trader consistently upticked their firm's quote within 5 minutes of the market close, often resulting in the firm's bid being the highest in the market by day's end. The following trading day, the trader would then downtick the bid. Backing away. Broker-dealers that trade on exchanges or OTC markets for their proprietary accounts are known as market makers. When acting as market makers, broker-dealers must stand behind their displayed quotes for size and price. That is, quotes are firm. If a market maker is contacted by another dealer or customer and fails to honor its quote, it is deemed a backing away violation. By doing so, the market maker violates FINRA and SEC rules and is subject to disciplinary action. Failing to honor a quote can lead to a monetary fine and/or suspension of the firm's ability to engage in market-making activities. Free riding. When a customer purchases securities in a cash or margin account, Regulation T mandates that payment be made promptly. In this context, prompt typically means by no later than 4 business days after the trade date, that is T+4, which is equivalent to by no later than 2 business days after regular way settlement, that is S+2. In a cash account, the full purchase price must be paid. However, in a margin account, a specified percentage of the purchase price is due, typically 50%. If the required amount is not paid by the Regulation T payment date, T+4 or S+2, the broker-dealer is obligated to close out the transaction by selling the securities and will freeze the account for 90 days. During the freeze period, the customer must pay for all purchases in advance. If advance payment is made during the 90 days, the customer is considered to have re-established credit and may once again be granted normal credit terms, that is, pay for trades within 4 days. A potential violation involving purchased securities is termed free riding. This prohibited practice can be explained in the following steps. 1. A customer purchases securities hoping for a price increase. 2. Before making payment, the securities appreciate in value. 3. The customer instructs their firm to liquidate a portion of the securities and use the sales proceeds to cover the payment requirement. 4. Because the customer's payment requirement is met without having deposited funds, this is classified as free riding. Prohibited trading practices and other trading rules. The SIE exam may include questions concerning various types of violations that can occur when broker-dealers trade securities. The following section summarizes some of FINRA's rules and interpretations. Anti-intimidation/coordination interpretation. Under this interpretation, the following actions are deemed inconsistent with the just and equitable principles of trade for any member or person associated with a member. To coordinate prices, including quotes, trades or trade reports, with any other member or person associated with a member. To direct or request another member to change a price, including a quote. To engage directly or indirectly in any conduct that threatens, harasses, coerces, intimidates, or otherwise attempts to influence another member or person associated with a member improperly. This includes, but is not limited to, any attempt to influence another member or person associated with a member to adjust or maintain a price or quote, regardless of whether it is displayed on an automated system operated by NASDAQ. to engage in conduct that retaliates against or discourages the competitive activities of another market maker or market participant. Payments to influence the market price. Broker-dealers are prohibited from paying any party to influence the market price of a security. While firms may advertise and issue research reports, they cannot compensate any electronic or public media outlet that can influence the price of a security. Best execution. If a broker-dealer fails to use reasonable diligence to assist customers in obtaining the best prices on purchases and sales, it violates FINRA and MSRB rules for municipal securities. To determine whether a member firm has exercised reasonable diligence, the following factors are considered: the general character of the market for the security, for example, price, volatility, relative liquidity, and available communications; the size and type of transaction; the number of markets checked; accessibility of the quotation; the terms and conditions of the order that resulted in the transaction. The market for municipal securities is not as centralized as that for corporate equity securities. Therefore, the standards for best execution should be viewed broadly, recognizing that municipal securities trade over the counter without a central exchange or platform. Time of trade disclosures. MSRB Rule G47. In addition to the best execution rule for municipal securities, a municipal securities dealer must disclose to a client all material information that is either known or reasonably accessible to the market. These time of trade disclosures must be made at or prior to the execution of the trade, and can be provided either verbally or in writing. The main purpose of this rule is to require dealers to share all relevant information concerning the securities their clients are considering buying or selling. Many municipal securities have unique features and characteristics that should be communicated to clients. Additionally, the disclosure rules apply regardless of whether the transaction is recommended or unsolicited, occurs in the primary or secondary market, or is a principal or agency transaction. The rule states that information is considered material if there is a substantial likelihood that a reasonable investor would regard it as important or significant when making an investment decision. A municipal securities dealer cannot fulfill its disclosure obligation simply by directing a customer to an established industry source or through disclosures made in general advertising materials. Interposition. Interposition refers to inserting a third party between a customer and the best market and is generally prohibited. This practice is specifically banned when it harms the customer. For instance, if a broker-dealer receives an order from a customer to buy 100 shares of XYZ at the market, and the best offer from any market maker is $40. Rather than buying directly from the market maker, the broker-dealer interposes another firm that buys the stock at $40 before selling it to the member firm at $41. The member firm then sells the stock to the customer at $42, with the two firms sharing the 1 point extra markup charged to the customer. However, interposition is not prohibited if a member firm can demonstrate that the execution was beneficial to its customer due to the involvement of a third party, for example using a broker's broker. This can occur when an order is crossed with a retail order from another firm, or when the member firm determines that the market could be adversely affected to the detriment of the customer by disclosing its identity. An order can also be routed through a third party if 1. That party is an established correspondent, 2. The name of the customer's member firm is provided, and 3. The customer is not charged for the correspondence services. However, a lack of sufficient personnel to effectively execute an order is not a valid reason for failing to secure the best price for a customer. To avoid overwhelming you with long videos, we'll keep it brief and easy to digest. Join us for a follow-up video where we will continue the discussion from this one. As always, please like this video so others can benefit as well. If you are a new viewer, we invite you to join our family with a free subscription.